You've been listening to the U.S. Supreme Court hearing arguments on whether former President Trump could be barred from re-election under the 14th Amendment. Trump's attorney argued the former president is not covered under Section 3 as an elected official, claiming also that he's not an officer of the United States. He also said that Section 3 can't apply to a candidate, only to those who hold office. He said that if the U.S. Supreme Court affirms the Colorado Supreme Court's decision, which removed Trump from the ballot in that state, that it would, quote, take away votes of potentially tens of millions of Americans. The plaintiff's attorney argued that President Trump disqualified himself by trying to disrupt the peaceful transfer of power by engaging in insurrection against the Constitution. He says that ultimately is what this court is going to decide, and it's the question of whether Trump's eligibility holds amid that issue for the country. So let's bring in senior national correspondent Terry Moran outside the Supreme Court, ABC News Supreme Court contributor Kate Shaw, and ABC News executive editorial producer John Santucci. Terry, what stood out to you from these arguments? Do you think you got any clues from which way the justices could be leaning by some of their questions here?
You know, Diane, in general, it's tough to read the tea leaves. You know, the questions sometimes are asked by justices to explore issues, but I think it felt pretty much to me like there is a strong majority against Colorado's position that it can disqualify Donald Trump from the ballot there. Now, how they get there, they might differ. And if you have been listening from the beginning of these arguments, good on you, because a great deal of what the justices did was the work of justices. It seemed they drilled down on two things. One that everybody can understand, one that lawyers and judges understand. And that's the one they spend the most time on. How does this work? That was clearly the question again and again in various forms. If Colorado can do this, by what standard? Under what burden of proof? If Colorado does it one way and somebody else does it another way, are we supposed to accept that? How is a system where individual states can declare someone an insurrectionist by whatever means? In Maine, it was the Secretary of State. Just bang, you're an insurrectionist, you're off the ballot. And in Colorado, there was a 5-day trial. What's the standard? How do we review it? What's expected of us? The other question that they were concerned about was democracy. And you could hear that, especially in Justice Kavanaugh's question. Justice Ketanji Brown Jackson followed up on it, which is that why should one state be able to decide for the rest of the country, basically the presidential election? First, by means of taking those electoral votes that state has away from one candidate. Second, by setting a precedent that other states might be able to follow on. And the answer from the lawyer for Colorado, well, the law, the 14th Amendment that we're dealing with is designed to protect elections from insurrectionists. And if it's messy, essentially, I mean, I think he was pinned and wriggling several times under fierce questioning, but his basic answer was, this is what the Constitution contemplates in order to protect the democracy from insurrectionists. And so part of the argument, very dense legalistic stuff, part of the argument, basic democracy stuff.
Yeah, we heard the Solicitor General there calling it the messiness of federalism and how that's sort of part of the system. Kate, the justices, though, they also grilled Trump's attorney on whether Section 3 is self-executing. Can you explain why that's so important to this case?
Absolutely. And I would agree with Terry in general. You know, this was not the hardest of arguments to read in terms of the tone and tenor of the justices. The argument went, maybe not surprisingly, very well for Donald Trump. It does seem as though there is a strong majority, maybe even close to a unanimous court, to rule for him on some grounds, although I think we do still have to wait and see what grounds. In terms of self-executing, right, the question here is, can Colorado just do this? Or does Congress have to pass a statute basically implementing the disqualification in Article 3, in the Section 3 of the 14th Amendment? And Congress hasn't passed such a statute here. So can Colorado essentially initiate this action? And there's some, you know, there's an early case decided by a single Supreme Court justice, not the full court, suggesting that legislation actually is necessary to implement Section 3. Actually, I think Trump's lawyer didn't solely rely on that case. It's called Griffin's case, in part because there's other precedent pointing in the other direction, but did say a combination of that early case and the fact that Congress, after the Civil War, after the passage of the 14th Amendment, did pass legislation actually implementing with respect to Confederate rebels aspects of the disqualification, and then also overrode using a different part of Section 3 that allows Congress to remove the disqualification. So Congress did that too. So the argument was really Congress did a lot in the early days to implement Section 3, and Congress hasn't done anything here. And Colorado can't act unless Congress does first. So that's essentially the self-execution argument. I think the justices were interested in it. I'm not sure if that's the way they will go, but a combination of that argument and an argument about the kind of practical consequences of letting a single state make such a dramatic change in the availability of candidates to voters kind of nationwide, or, the availability of the office of presidency to candidates seemed like something that justices were really troubled by.
And John, you had mentioned it was interesting to hear some of the democratically appointed justices, particularly Ketanji Brown Jackson, talking about, in a sense, seeing why this section of the 14th Amendment may not apply to the president.
And pointing out that it troubled her at one point that the president, the office of the president, wasn't mentioned in there, that according to their reading of it, it more focused on these electors that could be empowered by southern states after the Civil War, especially to, cause an insurrection, to take over the government, to influence in some way, not so much that one person, being the president, would suddenly have this grand power over all of the federal government. I think, for anybody that was expecting today to be, let's just say a reanalysis of January 6th, the day, and the insurrection, you didn't get that. What we all got, and Kate and Terry, I'm happy to visit you in Supreme Court land. Usually we don't do this, but the reality is that today was really just a parsing through of the 14th Amendment, of the Constitution, and anybody that thought you'd get the fireworks of what we usually see around anything involving Donald Trump in January 6th and the violence that happened up at the Capitol, this was not the day for that.
All right, Terry, John, Kate, thank you so much. And keep it right here. We will have continuing updates on ABC News Live throughout the day.